Look, being charged with a crime is an incredibly stressful and, frankly, confusing experience. Not just for you, but for your family too. Right now, the path forward probably seems anything but clear. So, the whole point of this is to pull back the curtain on the process and give you a clear, step by step roadmap of what you can expect as your case moves through the system. We're going to walk through this whole journey in 6 main stages. We'll start at the very beginning with the arrest, then we'll talk about the charges and how we start building the defense. After that, we hit the big one, the decision between a plea or going to trial. Then we'll cover how sentencing works, and finally, what your options are even after the case is resolved. Okay, so every single thing in the criminal justice system kicks off with an arrest. This is the moment the whole process is set in motion, and believe me, the steps you take right here in these first few hours are absolutely critical. Now, for an officer to arrest you, all they need is something called probable cause. Let's be really clear about what that is and isn't. It is not proof of guilt, not even close. It's just a reasonable belief that a crime happened and that you might be the person who did it. It's actually a pretty low legal bar to clear, which is why an arrest is just the start of the journey, not the end of it. The absolute moment you are arrested, your two most important constitutional rights kick in: the right to remain silent and the right to an attorney. You need to use them immediately. You just state clearly and calmly, "I am exercising my right to remain silent and I want a lawyer." That's it. After you say those words, you say nothing else. Nothing until your lawyer is sitting next to you. This is, without a doubt, the single most important thing you can do to protect yourself. Now, in some situations, instead of taking you to jail, an officer might just hand you a piece of paper called a notice to appear. It might feel less serious, but let me tell you, it's not a warning, it is a formal charge. It's a mandatory order to show up in court on a specific date. If you miss that date, a warrant will be issued for your arrest. You have to treat this with the exact same seriousness as a physical arrest. Okay, so if you are taken to jail, the clock starts ticking. By law, you have to see a judge within 24 hours for what's called a first appearance. It's a really quick hearing, but it's vital. 3 things happen. 1, the judge officially tells you what you're being charged with. 2, the judge glances at the police report to make sure there was probable cause for the arrest. And 3, this is the big one, the judge decides if you can be released and what your bond will be. It's really important to understand this. Bond or bail is not a punishment. It is not a fine. Its only legal purpose is to make sure you show up for your future court dates. That's it. A judge looks at things like your ties to the community, do you have a job, a family, and your prior record when they set that amount. This hearing is the very first chance for your attorney to stand up and argue for your release on fair and reasonable terms. All right, so once you're out of jail, the case moves into the next phase. This is where the state attorney's office, the prosecutors, officially file charges against you, and you're required to respond with a plea. That first formal court date is called the arraignment. Its purpose is really simple. The court formally reads the charges to you and you enter your plea. This is not a trial. No evidence gets presented, no witnesses testify. In fact, in a lot of cases, if you've hired an attorney, we can file the paperwork for you and waive your appearance, meaning you might not even have to go. You've basically got 3 plea options. Pleading guilty or no contest ends the case right there and moves you straight to sentencing. And for that reason, at the beginning of pretty much every single case, the standard move is to enter a plea of not guilty. This preserves all of your rights, it protects you, and it gives your legal team the time we need to actually dig in and investigate the case. You know, the reality is most criminal cases end with a plea agreement that's negotiated between the defense and the prosecutor. But it's so important to understand that the judge always has the final say. If you enter an open plea, that means there's no deal at all. You're basically throwing yourself at the mercy of the court and letting the judge decide your sentence entirely on their own. And that can be a very big risk. So once the arraignment is done, the real work starts. This is the investigation phase. This is where your defense team starts gathering up and analyzing every single piece of evidence in your case. We have a formal process for this called discovery. Your attorney files a notice that legally requires the prosecutor to hand over all of their evidence. I'm talking police reports, witness statements, body cam video, lab results, everything they have. This is how we find the strengths and, more importantly, the weaknesses in the case against you. But listen, this doesn't happen overnight. It takes time and patience to get everything and go through it all. Once we've reviewed all that evidence, if we spot legal problems, we attack them with what are called pre-trial motions. For example, a motion to dismiss argues that
Even if everything the state says is true, it's not actually a crime. A motion to suppress asks the judge to throw out evidence that was illegally obtained, and this goes right back to why you must remain silent. If the police question you improperly and get a statement, we can file a motion to have that confession thrown right out of court.
Okay, so once all the evidence is in and the motions have been argued, your case arrives at a huge fork in the road. This is the point where you, with the advice of your attorney, have to make the biggest decision in the case. Do we resolve it with a plea, or do we take it to trial? Now, for some people, especially first-time offenders, there might be other paths besides a typical plea. These are called diversionary programs, like pretrial diversion or drug court. They basically work like probation. You have a set of conditions you have to follow, but here's the best part. If you successfully complete the program, the state will dismiss the charges against you entirely. It's a fantastic outcome when it's an option.
If you do choose to go to trial, you have to burn this fundamental principle into your brain. You are presumed innocent. You don't have to prove a single thing. The entire weight, the entire burden is on the state to prove every single element of the crime they've charged you with. And they have to prove it beyond a reasonable doubt. That is the highest standard of proof we have in our entire legal system.
A trial follows a very rigid, structured path. It always starts with picking a jury. Then each side gives an opening statement, which is like a roadmap of their case. The state goes first and presents all its evidence and witnesses. Then, the defense has the option to present a case, but we don't have to. Finally, both sides give their closing arguments before handing the case over to the jury to deliberate and, hopefully, reach a unanimous verdict. All right, so if a case ends in a conviction, either because of a plea or a guilty verdict at trial, the next and final stage in the trial court is sentencing. For misdemeanors, the potential penalties are capped by law. A second-degree misdemeanor, the less serious kind, carries up to 60 days in jail and a $500 fine. A first-degree misdemeanor can go up to 1 year in jail and a $1,000 fine. Now remember, these are the maximums. Our job, as your defense, is to always argue for a sentence that is far, far below those top-end numbers. Felony sentencing is a whole different ballgame. It is way more complex. It's all governed by a points-based score sheet. The court assigns points for the crime you're charged with, and this is huge, for your prior criminal record. That final score determines the lowest possible prison sentence the judge is allowed to give. This is why it's absolutely essential that we make sure your record is scored perfectly. One little mistake can literally add years to a sentence. And while that score sheet sets the floor, the ceiling, the maximum penalties for felonies is incredibly high. We're talking up to 5 years for a third-degree felony, all the way up to 30 years or even life in prison for the most serious charges. The stakes are just enormous, which really highlights why a powerful, detailed defense is so critical. You know, even after a judge imposes a sentence, there can still be other legal steps to take. The case isn't always completely over just because the gavel has come down. If you're convicted at a trial, you have the right to an appeal. Now, an appeal isn't a do-over, it's not a new trial. It's where you ask a higher court to review the trial for any major legal mistakes the judge might have made. But you have to be aware of this. There is a rock-solid 30-day deadline from the day you are sentenced to file that notice of appeal. If you miss it, the right is gone. And finally, let's talk about a good outcome. If your case is dismissed, or you're found not guilty, you may be able to have the public record of your arrest sealed or expunged. This is such a powerful final step. It means you can legally deny the arrest ever happened on most job applications and background checks, which can help you truly move forward with a clean slate. So, as we wrap this up, I really want to focus on your role in your own defense. First, remember your right to remain silent. Use it. Second, understand this whole thing is a marathon, not a sprint. Be patient. Third, be an active partner with your attorney. Ask us questions. Tell us everything. And finally, remember this. While your lawyer is here to give you advice and guidance, the biggest decisions, like whether to take a plea deal or go to trial, that final decision is always yours to make. So, what is your most important next step? It's to get prepared. Before you meet with your lawyer, sit down and write out everything that happened. Make a list of every question you have. Gather up any paperwork you've been given. Clear, open, and honest communication with your attorney is the absolute foundation of a strong defense. And please remember, everything we've talked about today has been a general overview. The unique facts of your case are what will truly determine the right path forward for you.